doctrine of caveat emptor imposes no duty of affirmative disclosure upon a seller of real estate regarding the condition of the property. This doctrine operates to bar anyone who fails to inform themselves of the fitness and value of their purchase from rescinding the contract. But what if no amount of due care would reveal to a buyer a problem with the property? And what if the seller created or knew about the problem? Should caveat emptor bar a buyer from rescinding a contract in these circumstances? This was the issue the New York Supreme Court was asked to resolve in the famous case of Stambovsky versus Ackley. In this case, Stambovsky, a non-local buyer, contracted to buy Ackley's house. Even though Ackley knew her house was haunted when she sold it to Stambovsky, she did not disclose that information. Previously, Ackley had advertised the fact that her house was haunted by reporting it to Reader's Digest and the local press. After Stambovsky learned that the house was haunted, he filed a lawsuit seeking to rescind the contract. Because Ackley made no affirmative misrepresentations to Stambovsky about the property, the lower court held that Stambovsky could not rescind the contract and dismissed the lawsuit. Stambovsky appealed. The issue before the New York Supreme Court was whether the doctrine of caveat emptor barred Stambovsky from rescinding the contract. The court held that the doctrine of caveat emptor did not bar Stambovsky from rescinding the contract with Ackley. In reaching its decision, the court was quick to note the difference between Stambovsky's lawsuit and the legal precedent supporting the lower court's dismissal. While the legal precedent concerned cases dealing with problems with the property that were discoverable through inspection or title search, the case at hand concerned a matter impacting the property that no inspection or title search might reveal, the home's reputation for being haunted. The court, therefore, carved out an exception to the harsh caveat emptor rule. Under this exception, where a condition that has been created by the seller materially impairs the value of the contract and is within the knowledge of the seller or unlikely to be discovered by a prudent purchaser exercising due care with respect to the subject transaction, non-disclosure constitutes a basis for rescission as a matter of equity. Applying this exception to the facts, the court reversed the lower court's decision, reinstating the lawsuit. Specifically, the court ruled that because Ackley had taken advantage of Stambovsky's ignorance of the home's reputation for being haunted, which she had created and perpetuated, and about which Stambovsky would have no reason to inquire, rescission of the contract was entirely appropriate.